welcome to the program. Tonight, part 2 of our behind-the-scenes look into the workings of the Territory's Bush Courts. Former Chief Magistrate Hilary Hannam and Magistrate Sue Oliver discuss the issues overwhelming the justice system and the challenge of meeting community expectations.
Bush courts have been a feature of the Northern Territory's justice system for decades. Beyond the main centres, court convenes regularly at more than 30 remote communities. At Aliangoola on Grid Island in the Gulf of Carpentaria and at Goombullunya in Western Arnhem Land, court comes to town once a month. Magistrates and their staff, prosecutors and defence counsel often travel together for 2 to 3 day sessions which handle up to 100 cases. Goombullunya in Western Arnhem Land, the annex of a council building serves as the courthouse. Today, there's the usual caseload of juvenile matters.
The saddest are, of course, those who are coming into the system very young. The saddest are those who come who are not accompanied by a responsible adult. There's far too many who are under the care of the Office of Children and Families, who are also in the criminal justice system. The girls are very sad because girls are often very damaged before they're committing criminal offences.
Young people have very particular needs to be addressed when you're dealing with them as offenders. And for many of those young people, they have parents who are abusing alcohol or abusing drugs, or simply are just ineffective in terms of parenting. They have not been going to school, and they'll go back to a situation where they don't go back to school. They are often young people who have extreme disadvantage.
Overall, I think the children are more harmed than harming. I think they are more wronged against, particularly the very young ones who come into the system. That's not to say there aren't some awful crimes being committed, particularly by older youths who are approaching adulthood and who definitely know better and know that there are some awful crimes. But overall, I think these are kids who've been really let down by others.
Unfortunately, the nature of the youth justice jurisdiction is that the young people who come before it will have complicated matters and will have serious problems that can't really be fixed by imposing a sentence. Their problems will go back to education, to their family life, to things like drug and alcohol issues. Those things are complicated, and those are the issues that really need to be dealt with. So when young people commit crime, they're going to have to expect that they'll come before a court, but we need to be honest that really the criminal justice system isn't going to be any use in getting those young people back on track. And in fact, what the evidence shows is that sending young people to detention or to prison makes them more likely to commit further offences in the future, so it's actually counterproductive.
I think it's particularly concerning to take young people from a community into a detention centre in Darwin because they don't have family support and a lot of them don't speak English, and so they're extremely isolated in detention. But there are some cases that call for that, and if I've reached the conclusion that this offending does call for the person to be given a custodial order, then that's the order that I have to make.
In Australia, a great sense of our own individuality and strong emphasis on parents' rights and on rights generally rather than responsibilities. And often these children warning bells do ring very strongly through the education system or the child protection system. I quite often come across reports of children who've had shockingly traumatised experience as young individuals, and you can see that personality disorders and the antisocial personality disorders and the issues that come up for criminal offending are emerging from a young age, and then you'll start to see them in the criminal justice system from a young age. It's much better to be intervening at, primary school age than trying to pick up the pieces, and also having a person who's a risk to the community and a non-productive member of the society who's going to spend most of their life in jail.
We see a lot of young people who have been affected by the amount of alcohol that their mothers drank during pregnancy. I would say in the last month, 5 weeks, I have come across at least 6 young people who have serious intellectual disabilities. I suppose I despair about that because I just don't know what the answer is. It's very difficult for a court, a criminal court dealing with criminal matters, to appropriately deal with someone who has a mental age of about 8. I'm seeing increasingly more of those cases, and I think we will see more and more of those cases. It's one of those aspects of alcohol abuse, again, that I think is not widely appreciated. People think of alcohol abuse as affecting the person who's abusing the alcohol. They don't always appreciate what the long-term implications of that are. That is, that children born to that person may well be quite damaged.
Sadly enough, there is a lot of trauma in Indigenous communities and in communities we often see who are overrepresented in criminal offences, like communities where people have got the impacts of poverty and poor education and intergenerational unemployment and substance abuse, and they're the sorts of community environments where there is a lot of trauma, and children raised in those environments, we know that their brains develop in certain ways, and the capacity to regulate your emotions develop in particular ways.
Such influences are directly reflected in the Northern Territory's imprisonment rates. The statistics are startling. The Territory locks up people at 5 times the national average, and more than 85% of prisoners are Aboriginal. That means that 1 out of every 20 Aboriginal men is in jail. Mandatory jail for crimes of violence is a major reason for the rate of imprisonment having grown by more than 70% in the decade to 2012.
Unfortunately, domestic violence is a large part of the work we do, and it's something that we see we just simply see too often.
I would ask that Your Honour take into account that it was not a sustained assault, and albeit, Your Honour, it's conceded that any assault on a female is a serious offence.
By far the majority of criminal offences arise because of people's inability to control their emotions, and a lot of people's inability to control their emotions goes back to issues from their own past and their own childhood and those sorts of things. It is a very, very common thing to see.
He wasn't in a fit state to be around his partner due to his anger.
But what does he say about why he did it in the first place?
Your Honour, he says that they were having an argument just in relation to their children, and Mr Nalorman has effectively lost his temper, and he has lashed out at his wife.
Generational change of attitude just has not yet occurred here. The idea that men can control women's lives is still, sadly enough, new thinking for too many people here. Violence between people, in families, in homes, is a matter of enormous concern to the community. Now, you may have felt angry, you may have felt upset, but it is never, ever acceptable to hit a person, especially not to hit a person who you should be caring about, who is your wife, who's the mother of your children. It concerns me that maybe one of the children was around, because probably the single most damaging thing that people can do in their child's life and for the future, and it's very much connected to future offending and a whole range of issues for a person's life, is have the child exposed to violence in their home. Because if they're in that constant state of fear, that constant state of trauma, then again it goes back to this whole issue of brain development, emotions. It can have effect on cognitive development, it can have effect on emotional development, capacity to form relationships, patterning their own violent behaviour, a whole range of activities. It's completely unacceptable behaviour, both for the victim herself but also for your children. And if you have male children and they're exposed to that sort of thing, they will grow up learning thinking that that's acceptable when you get angry, and female children will think that it's normal to be hit. Now, the law says that in these sort of cases, I have to send you to jail. I think that sending you to jail for this sort of offence is the right sentence. You'll be released after a short period of time, and you'll be required to complete a special program through the Department of Corrections called the Indigenous Family Violence Program. So for that matter, the court's expected to do all sorts of things for people who have complex problems that aren't just legal problems. They're complex social problems, and they relate to poverty and education and intergenerational violence and trauma and all those things, and yet we are expected to do something.
The order that the court is being asked to make today is an order that you simply not do any harm to Mr. Warramurra. Mr. Warramurra is your husband. Yes. So the order would be that you not cause him any harm or make any threats to cause him any harm or try to harm him in any way. If you set a period of imprisonment for someone, they go off to prison, they come back, nothing's changed. Whereas if you put a person on an order, and particularly an order that requires supervision by corrections, the hope is that under supervision, some things around their life might change. And those things might prevent the reoffending. All right, Ms Namanadurti, you're not to assault or threaten to assault Mr Warramurra, and not to harass. You know what harass means? Yeah. Or make threats or verbally abuse him. And that will be for 12 months, all right? Now, you do need to understand this is a court domestic violence order. If you were to break one of those conditions that I've explained to you, then you could be charged with a criminal offence. All right, thank you very much. In a small community of a few hundred people, to say you must not have any contact with this person ignores the obvious that they're going to pass them in the street on a regular basis. So you do have to, again, I think, be quite, to think very carefully in making those orders, what is appropriate for a particular situation.
It's very hard because we've got to be given the tools of what is it we can do. I mean, we would like to be able to treat a person, assist in crafting a sentence that does treat their underlying issues, like their substance abuse, assist them with their literacy to get them back into employment. We'd like to be able to do those sorts of things, and I think the community sort of expects us to.
In remote locations like Groote Eylandt in the Gulf of Carpentaria, alcohol is a big factor behind criminal offending, even though its possession carries huge fines. 60% of all assaults and 2/3 of all domestic violence incidents involve alcohol. But magistrates in the Territory have limited opportunities to place offenders on rehabilitation programs or community work orders as an alternative to jail.
If nothing is done, nothing different than what we're doing collectively as a society for youths who are offending, especially male, Indigenous, who came into contact with the system at a young age, it is inevitable that they will spend their adult life largely in custody.
If you look at somebody who you think, notwithstanding the crime that they've committed, that their prospects of rehabilitation are actually good, then my view is that an order which seeks to assist that rehabilitation is probably in the best interests of the community at large. Whereas if that person simply goes to prison for 3 months, they come back, there's nobody checking on them when they come out, they're a free agent again, they will go back to, and the evidence is very clear that this is what happens, they just go back to their former lifestyle.
Your Honour, Mr Warramurra, he's a young man who's found himself indeed in some trouble today and is very concerned about the outcome of this court. Your Honour, this is clearly serious offending, and it's an issue en route. No doubt these break-ins, the community is sick of it. I would put it to the court that it is a petty motive to steal this grog, and it's serious offending done, I think, in a childish manner. And I know that my client feels foolish for risking what he's risking his liberty to steal a few bottles of alcohol.
The Section 213 offences are aggravated property offences. Sometimes jail is necessary as a punishment. I mean, there are some people that do need to be removed from the community. They have committed very serious crimes. They need to be given serious sentences of imprisonment. They need to be removed from the community. But not everyone's the same. Mr Hockley, I wouldn't perhaps ordinarily be necessarily contemplating a community custody order, particularly because of the prevalence of this sort of offending in this community in recent times. A justice system that simply treats everyone as being the same, as needing the same outcome, I think is a very ineffective justice system. All right, so Mr Warramurra, I'm going to ask you to talk to the Community Corrections Officer, lady sitting over there, and she's going to talk to you, and then she's going to give me an assessment as to whether you are suitable for what is called a community custody order. It's effectively a sentence of imprisonment that you serve in the community. But there are other things attached to it. For example, you have to do community work as part of it as well.
Mr Jokaber initially had been perhaps not having sufficient insight as to the extent of his alcohol problem, but seems to have accepted now that he does need to do something about it and that residential rehab is the way to go.
That's certainly what he said to me, right?
Yes. What we actually need is the right kind of program and the right kind of treatment for the particular issue. I'm just concerned about practically how it's going to happen. We have a very small population and we have a lack of highly specialised service providers in a whole lot of areas that have got implications for the court. It just makes it very difficult because the community does have high expectations of what we're able to achieve, and it's really hard to achieve it without those tools.
In spite of the alarmingly high number of Aboriginal people in the Northern Territory's criminal justice system, the Territory stands out as the only jurisdiction without an Indigenous justice program, like the Koori courts in Victoria or Circle sentencing in New South Wales. That leaves Northern Territory magistrates without culturally relevant sentencing options, and the regime of mandatory jail for crimes of violence further ties their hands.
Generally, governments say we have to bring in mandatory sentences because the sentences that are imposed by the judiciary are too low. But we have a system that's built into the judicial system, and that's the appeal process. Now, there are a tiny handful of appeals against the sentences of the magistrates for an inadequate sentence. The vast majority of appeals are that our sentences are too harsh.
There isn't a one-size-fits-all scheme of sentencing, and anything which, in my view, attempts to do that runs the risk of giving people outcomes that don't fit what they've done and don't assist the community because they don't address the factors that have caused the person to offend in the first place.
Silence, all stand. The Darwin Court of Summary Jurisdiction is now in session. Please be seated.
There's certainly been cases where I have thought that the sentence that I am required to impose is not a sentence that I would have imposed if I had discretion.
The defendant became very angry, got up from his seat and stood over the victim, grabbed her by the hair and pushed her head hard into the floor. The victim advised the defendant she was going to call the police. The defendant stated, "Go on and do it."
On the other hand, there are often cases where it doesn't matter that there's a mandatory minimum period of imprisonment because I would have given that person much more than that in any event. So, you know, it I suppose cuts a bit both ways. But yes, there are certainly cases from time to time that I've come across that I have thought have worked an injustice for that person.
Sentencing options have shrunk in the Northern Territory as a new Conservative government dismantles alternative forums like the SMART Court. SMART is an acronym for Substance Misuse Assessment and Referral for Treatment. The court offered diversionary programs for non-violent offenders who had a substance abuse problem underpinning their offending. Chief Magistrate Hilary Hannam was a champion of the SMART Court. Its demise was an ingredient in her decision to accept an appointment as a judge of the Family Court of Australia. With the SMART Court gone, Hilary Hannam says jail will now be the inevitable option.
There won't be deterrence because we know that sending people to jail does not act as a deterrent, and certainly it won't be promoting their rehabilitation. So inevitably the jail population will continue to increase. There won't be the inroads made on recidivism, and it will be much worse and much more expensive for the people of the Northern Territory.
The SMART Court ran for 18 months, and ABC cameras recorded its last sittings.
Darwin SMART Court is now in session. Please be seated.
Each individual has an assessment done by a clinician for their therapeutic needs in terms of their treatment for either their alcohol or illicit substance, or sometimes prescription substance needs, whatever they've got, whatever their substance of abuse is. I know that residential rehab is going to be a much bigger imposition on your life, but I think that your entrenched pattern of substance use has been going on for so long that really a residential program is the way to go. Mr. Carlton was on drug screening twice a week. These are people who have been cycling in and out of custody, and without this level of intervention would inevitably be going into custody. I think that you recognise that you either address this now or you're going to...
When I'm watching the kids, I don't worry about it, and I do want to do it.
Great, okay, that's a good attitude and we're pleased. Okay, see you in 2 weeks. It's very high degree of monitoring, far greater monitoring than anyone would have on any other form of order. Now, the not submitting to the urine drug screen, there will have to be a sanction for that because they get breath tested or urine tested throughout the whole of the period, randomly at intervals determined by the court. If you have had that test, is there anything that you need to tell us about in terms of using?
No, not at all.
No.
For all the years that I've been using the drugs and that, there's always a psychological effect. I reckon counselling that received in the thing might be able to help me with that.
Well, I'm really glad that you want to go for something really sustained like a residential program, and that's a very, very good program, that one. They have their counselling, but they also come back to the court every 2 weeks and they have a review with the court. It's really important that we're able to get a hold of you because it's that testing that keeps you honest. Now, anyone who thinks that it's a soft option, you can see it's not a soft option. The court is pretty tough with them. People have got to be accountable if they have had slip-ups, both in terms of speaking to the court and having sanctions imposed. So that will be 2 sanctions. Now, I need to tell you, you're now up to 10. I think to have to serve, and when you get up to 14 days, that's usually when you have to serve them, would be a huge step backwards for you.
Yeah.
You don't want to jeopardise that job. You don't want to go back where you've been before. So whatever you need to do to stay strong, it is really probably more important than ever. It's much tougher than doing your time. And sadly enough, some people say, no, I don't want to go to Smart Court, I'd rather do my time. And for a number of people, it is easier to do their time. Mr Foster's, when we were talking about in the team meeting, that I think you were commenting, Mr Marlin, that he's really turned the corner. But I can remember, I think it was 3 reviews ago where you were in quite a precarious position, and you've really turned yourself around since then, and I'm very impressed. And now I think we need to make sure that there's some rewards for that by means of removing some sanctions. They are accountable, but at the same time they are also really praised and given positive reinforcement that they do well. Now, for some people, that's the first time they've ever heard anything positive from anyone in authority in their lives. Well, I will write this down, that that's the reward that should be the one that's given for the next 3 weeks if you have the 100% compliance, and that's as well as having sanctions lifted.
Thank you.
Is that okay?
That's fine.
That's fine. We all can't believe what a different person you are to the one at the beginning. In fact, not just the beginning, right up until the most recent time where you really said, this time I'm going to do it. It recognises that substance abuse does not occur in a vacuum, and it's no use just treating the substance abuse if you don't treat the other reasons why people do abuse. And you've got to keep up that good work right to the very end, and stay strong, and, you know, don't even think about falling back in those old ways. All right, so, Mr Shields, your long association with the court's come to an end, and this is one of the sort of few things in life where we don't want to see repeat customers.
It is what I came up here to do, and it was fantastic. We had an 18 months where it was really exciting, and it's very rewarding, and we were there for the long term. It had a number of features that were just simply that they don't exist in any other manner in which people are sentenced.
Hilary Hannam is now a judge of the family court at Western Sydney, and as demanding as that new role is, it won't offer anything like the environment and diversity which is the realm of the Northern Territory Magistrate.
It's a huge jurisdiction. We've got more people living in very remote communities. We've got far more disadvantaged people, and we know that disadvantage and poverty and lack of employment and all those things, substance misuse, exposure to violence, dysfunctional families and communities are all things that relate to crime. And they're all things, of course, that are outside the court's control. So it just makes the whole environment a lot more difficult and challenging.
And that concludes our special series into the Northern Territory Magistrates Courts. Please join us again next week for 7:30 NT. Have a great weekend.